respect of the impugned order is pending before the Honorable Central Administrative Tribunal, and the next date is on 23rd September. This is the only urgency, my lord. If it can be taken up on Monday, subject to your lordship's convenience.
It has gone out of the list.
My lord.
Why?
My lord, last day I had appeared and had submitted my supplementary affidavit. Thereafter was probably not called. Subject to correction, it may not have been
How
called.
it can be? Must have been called if it was in the list. What is going to happen on 24th in the tribunal? Contempt is listed.
The
for what?
only thing, my lord, since the contempt proceedings is pending, that is the
Every
only
matter where it is pending, we are not taking up. If something is happening, if some order is passed, some appearance is directed, then we can understand. Otherwise,
if it can be taken up on Monday, my lord, subject to your lordship's
we will not be now
because it's
the next week not in a position to do anything. If there is some compelling circumstance, some order has been passed, some precipitatory action is being taken, then we can
because
understand.
on the last occasion in the contempt proceedings, my client was directed to bring a stay order from the Honorable High Court. We could not get on the earlier
We
occasion.
don't
I had
know why it was not taken up on that day. Perhaps you have not appeared. Perhaps you have not appeared. Otherwise, how it will go out of the list? It cannot. It cannot, sir. You bring the last day's order. You mention on Monday.
last day's order, there's no order to go out of the list. That order is not there in the server. There is no
When was it listed?
17th. It was listed for the last
17th.
17th, my lord. 17th of this month, my lord.
We'll see. Just give the case number. We are not going to list it. Just give the case number. We'll see what is the position. Why it has gone out of the list. File लाके दिखाना उसको. Show the file sometime. Yes. Call the list. Yes.
Item number 1.
Item number 1, my lord.
I am appearing on behalf of the Union of India, my lord.
Lord, Mr. Ujjal Rai, my lord, is appearing on behalf of the respondent, my lord. He's on leave at court number 1, my lord, seeking 1 day's accommodation, my lord.
Let us see.
My lord.
Wait. Tribunal?
My lord, honorable tribunal awarded to the applicant a revision of pension from the date of superannuation on notional basis
What
and
is
the
it?
actual payment with arrears from 3 years preceding the date of filing the OA.
So from
Second
2012,
point,
from 2012.
Second point, my lord, the honorable tribunal observed that the respondents had not maintained the records and they are not able to verify the claim of the applicant. From the records that he was working as a substitute does not hold much significance and justification in as much as it is the respondents who are bound to maintain a register of records or names of all the substitutes as contemplated in Rule 15E.
Yes.
My lord, thereafter, third point, the honorable tribunal noted that the daily wages period, casual service period, and substitute period, 50% of which has to be counted for the grant of pensionary benefit, citing the decision rendered by the honorable apex court in the case of Rakesh Kumar versus Union of India and others, my lord. My lord, arguable points to this writ petition, my lord. First point, however, this relief was never sought by the applicant. The legal principle governing judicial relief dictates that any decision must be limited strictly to what the applicant has pleaded and substantiate. Awarding a pension revision not only diverges from this standard but also undermines the principle of claim-specific adjudication, resulting in a decision that is legally unsound. Second point, my lord, it is worth mentioning that the tribunal failed to appreciate that record keeping is subject to a time limit. The impugn order was passed in 2025, whereas the relevant records date back to 1982, my lord. Expecting the respondents to preserve records for 43 years is an overestimation, especially considering the fact that the respondents have already stated in their reply that the preservation period of such record as per Southeastern Railway Establishment serial number 90/1999 is only 10 years. We are maintained 10 years, my lord. Third, arguable point, my lord. In this case, the Union of India others versus Rakesh Kumar, the Honorable Apex Court overturned the ruling of the Delhi High Court and held in favor of the Union of India that casual railway workers, whether before or after obtaining temporary status, are entitled to have 50% of their service till regularization, renoked for the purpose of calculation of pension. It is
You are
pertinent to
representing all
note.
the respondents.
My lord, yes.
All right, not today, ask him to be here.
My lord, I'm grateful.
My lord, affidavit service be kept on record, my lord.
Yes, affidavit of service taken on record. Matter is adjourned for the day. As prayed by learned advocate for the respondent, matter is adjourned for the day.
Much obliged.
Item number 2,
That is.
we are challenging an order. Yes, my sir.
What the respondent?
And on the last date, at last page of second volume, my lord. No, madam. And original direction was to pass a reasoned order. That reasoned order contained a statement that you will be treated with similarly as another person. That case was pending before the Honorable Supreme Court. That got disposed of. The appeal was dismissed, but the Supreme Court recorded that this will not be a binding precedent.
Open.
Yes, my lord. So, my lord, one thing today also I have received instructions, my lord. We can always pass a new reasoned order because even our own order does not stand. Our own reasoned order, first round is old pension. Well, similar than
NPS, he wanted the old pension scheme.
old pension
So
scheme.
it's the issue of NPS not applicable.
Yes. So original order did not decide on the issue. It said that you pass a reasoned order.
Then the reason order was
Reason
passed,
order
which was
passed,
challenged
matlab,
before
but
the
reason-
tribunal.
Yes, matlab.
It was not
Huh?
challenged, contempt was.
No, it was not challenged. Contempt was filed, madam, directly against the reasoned order.
So this is arising out of contempt.
Yes, madam.
Yes.
No, the read petition is a defective one.
Where is the,
Read petition is
I am
defective.
submitting, my lord. They themselves has admitted. First of all, my lord, just.
where is the order which has been violated by the
Yes,
tribunal?
I am submitting.
Where is the order which was violated?
But you can see.
Wait. Order. যেটা এই যে
Kindly come to page number
এই অর্ডারটা
111.
Page number?
But
first
there-
volume
Page number, sir?
111. No,
This is my pagination here, sir, 111.
111.
111.
So this is the order violation of which has been alleged in the contempt. Just let us read one.
I am reading the last paragraph.
Let us read.
ওইটা বার করো, ওটা কোন পাতায় আমরা রিজন অর্ডারটা
Extend the benefit to the applicant.
নাইন তো এটা 2024 আমরা এখন 12 নভেম্বর তারপর এসে কি করে লিস্ট আউট এটা দেখো না এই অর্ডারটাও বোধহয় লাস্ট ভলিউম
Kindly see the next page, 115. They are past speaking order. I am reading the last paragraph of this order.
Yes.
115. Here they have admitted, you are informed that your case being similarly circumstanced with way number such and such,
আলাদা করে
filed by C. Josephine Japan, will be processed, considered subject to outcome of the SLP. Now they have admitted, I am the similarly circumstanced person vis-a-vis to the Josephine Jaipal. Just now I am saying, my lord, Josephine Jaipal and C. Biswajit Biswas.
We are asking you, where is the contempt? We are not,
Yes, I am.
we are not looking into the correctness of the order.
Now,
We are only to see where is the contempt.
yes, contempt. Now the contempt order, my lord, kindly see, my learned pen did not disclose all the orders passed by the contempt. He did not disclose because the last order has passed, which is not under challenge. Their counsel did not appear in the last occasion. There is a last order passed by this court whereby
No.
that is 8/7/2025.
Yes.
But it is not under the challenge. In 8/7/2025.
What is not under challenge, we are not considering. We are only considering this order.
How the contempt is lying, my lord is asking. Now, like Lordship, kindly see, they are speaking order I am reading. They themselves admitted that you are similarly
Oh,
circumcised.
it is still pending. It was pending before the tribunal.
Apex court dismissed.
No.
I am giving the order.
You have challenged the interim order of the tribunal.
Interim order. They did not challenge the original order.
My lord, we had challenged
not
taking
challenge the
cognizance
original.
of this order. My notice was issued, so the court has taken cognizance. When there is already a,
Their counsel did not appear
when there is,
after issuing
we
the
have,
notice.
we have passed the speaking order, my lord.
So why have you filed? Why have you challenged this order? What is the occasion to challenge this order?
Challenge because
the
notice
original
has been, the court has taken cognizance, my lord.
What the court has taken cognizance?
Court simply issuing the notice.
It was on admission, my lord.
He can,
Because issue notice is an order to be challenged.
he can submit by file an affidavit.
Then every case after notice contempt has to come before the High Court.
Arre,
Only issuance of the notice he has challenged.
We thought it was a final order. What is this? Issue notice and you are before the
Yes.
High Court. Just see the order, sir. Just see the order. There is nothing.
Admit issue notice.
There is nothing. What can be done in this?
if
We don't
subse-
know.
If during pendency of this order, subsequent orders have been passed, your lordship can take cognizance of those orders.
Huh?
If subsequent orders have been passed, your lordship can take.
We are not going to oversee a contempt proceeding before the CAT. Unless some order is passed, which
Right.
really you are aggrieved by the order, it is going.
Our cases, it is not maintainable.
We don't know. Who is stopping you from raising the issue of maintainability there? There is no ruling on this aspect.
Yes.
And where is that objection recorded in the order that it is not maintainable? Show us.
No, this was on admission, ma'am. This
Nobody
was
has
on admission.
Therefore, this is not the stage. Nothing can be done. We don't want to encourage such things. Then in every case, contempt is filed. You are asked to file a reply. You will come to the High Court.
But
It's
the
not- we
other
cannot countenance such a situation.
The practice of filing a contempt in every matter, that also has to be discouraged, your lordship. By your lordship.
Filing of
My
a
lord,
writ
it is
petition
both
in
ways.
every matter.
Well, contempt, my lord, they could have filed an
Anything
OM.
can be said that you are
Right.
filing a writ
What I am
petition in
saying,
every
I
matter.
understand, but what I am also saying the same thing. There are two sides of the same issue.
This is not a case. You go and there is no this order. How does it prejudice you? Mere issuance of a notice in a contempt proceedings has been challenged by way of the present writ petition. Stop.
Get
Item number 3, similar I am for the well, it starts from page 133. Look, I have only the rules I have found. The competent authority that is under the guidelines. Business. These are transfer rules, that. Well, that is at order of transfer at page 85. 85. There is other places also. My lord? No, till, my lord, I have been working till last day before yesterday. Only yesterday they have issued the release order and will hand over the charge to some other person. Only yesterday. Malab, when the matter is taken up for hearing, they issued this. Well, see this letter. They have been not sharp upon me. They have sent in my WhatsApp message.
What is your representation? Please come to your representation, page
That has
71.
been at that point of
What
time.
is this at that point of time?
Malas,
You have never raised any issue regarding it being issued by a competent or incompetent authority.
kindly see the companion. That is the as per rule.
Where have you raised this issue in the OA? Where have you raised this issue in your representation?
That have been raised in my rejoinder.
Very good. New case by rejoinder. Show us that it can be done.
But that cannot be. But as
Somehow
per
you
the
want to
rules,
avoid.
kindly see.
Somehow you want to avoid the transfer. That is all.
Not that.
Sorry.
But
We are not going to interfere at all.
The director of printing is the.
We are not
kindly see-
concerned. We are not concerned.
Well, kindly see the.
We
rules.
will not. You have not raised this ground. We are not going to look into it. We will not look into it. You have said that give me 1 year to join. And this representation you have given in 2022.
That's-
Today we are in 25.
Well, that I
And
cannot.
relieving order has been issued yesterday. It's a very unfortunate circumstance for you. What is this? You have a right to stay wherever you want.
No, kindly. My.
That is precisely what you are claiming, sir.
Now, my daughter is now
Sit down,
appeared
sorry.
to exam. Kindly.
Third learned
answer this
advocate
aspect.
for-
Kindly- Consider
So
this.
tribunal considered and rightly rejected because you cannot make out a new case in rejoinder.
There is no such finding that the new case has been made out in the.
That we will say because it is an admitted position. You have filed it in the
Who
rejoinder.
said the director of printing is the transferring authority?
No, it does not.
You also can see the company. Kindly see. But
We have asked you to
this-
show the rule. You have not shown it.
Yes, kindly see the rules.
This is not a rule. These are guidelines.
this is the
Guidelines are
company.
not enforced.
Another company name is
So
there.
every 5 minutes you will bring
This
out
is the last term. Kindly go through this.
unnecessarily.
Sorry, Mark.
Somehow you want to stay at the same place.
No, no.
Nothing else. There is nothing
My
else.
daughter exemption is in next year.
Everybody is having problems in transfer. You are not the only person. That's a chain transfer. So many people have been transferred.
No, only below I
Only I have been transferred from station.
The same station.
Yes, that we were going to expected
All
that
the
you will say.
others are all in the same station.
So there is a equality in matter of transfer.
Kindly this my daughter.
Argue a law. Don't just raise something just for the sake of argument. What does the law say?
Kindly see.
I have only been transferred from the station, therefore I cannot.
That I can't say.
What a wonderful submission. You are
Kindly
claiming
see the
parity
director
and
of
equality
printing
in
is also-
transfer.
But that is there.
This is not a rule.
Kindly see the
Sorry.
page tape.
This
Page
is
number
not
10.
a rule, sir. This is not a rule. This is a compendium.
There is a specific provision that director of printing is the authority to transfer. I am an accountant.
Show from the rule that you are subject to this. It says power to appoint. Who is your appointing authority?
Director of printing.
Show us.
That is in the letter of appointment. Letter of appointment.
Letter of appointment. You were at that time on a different post. Today you
No,
are an
accountant. all time in the post of accountant.
Show us from the rule. You have not raised this issue anywhere. You are stalling a transfer since the last 3 years. As if you have a right to continue at Calcutta forever, for all your life.
Well, kindly come to page 62. That is my appointment letter issued by the Director of Printing.
Show us from the rule. We are not concerned.
Yes.
Page
So they have not denied that the power. They are also relying upon the DOPT. And as per the DOPT, that rules for transfer, guidelines of transfer has been issued. And that was only the committee can recommend it for my transfer. Let them produce that recommendation that they have been recommended me for transfer from here to there.
Enough. Enough. Heard learned counsel for the writ petitioner as well as the
Item number 4.
My lord, I am for the petition.
For the Respondents Union of India.
My lord, this order has been challenged by the part portion of the order. The petitioner's claim was before the tribunal after retirement withholding the benefit of gratuity, pension,
After retirement,
withholding the pension, gratuity, leave encashment and house rent allowance.
yes,
Leave encashment has been granted by the learned tribunal and house rent allowance directing the authority to consider. But the payment of gratuity amount and the pension, full pension, even except the provisional pension has been granted. Against the such refusal matter that application has
so
been filed.
basically you are here only for gratuity.
Gratuity and full pension.
What full pension? Provisional pension is full pension. What full pension, sir? So you are here only for gratuity.
Gratuity.
Yes.
My lord, during continuation of the service of the petitioners,
Yes.
he was implicated two criminal cases, but not related to the official matter.
Yes. He is in the railways.
During, my lord,
Which department?
postal
Postal
department.
department.
Postal. He is an officer of the ex-employee of the postal department.
Date of
Subsequent-
retirement?
My lord,
Date of retirement.
date of 31st May 2023.
So you were allowed to retire
Yes,
and because there is no departmental proceeding, only criminal proceeding is pending.
yes. During continuation of service and no departmental proceeding
Yeah.
has been initiated.
That we
Again-
have understood. Yes. What is the legal position? Let us see.
Legal position is where the case is non-related to the official matter. In view of that, and no departmental proceedings has been initiated,
Then it cannot be
So-
withheld.
my lord. The authority cannot withhold the gratuity. And there are numerous observations passed by the.
Now let
Honorable
us
Chief.
see what the tribunal has held.
Paragraph 17, my lord, of the order. Wait a minute. You can follow. Since there is no pecuniary loss of the government and there is no scope to recover any money from the amount, and accordingly he is entitled. That was the prayer of my before my lord. এটা তো লেখা আছে আমার council. Okay. That the pension is not be treated as a bounty payable on the sweet of will of the pleasure of the department, my lord, concerned.
TCS pension.
My lord, I have got.
Lordships will be required to look into CCS pension rules 2021.
পুরোটা লিখতে কি হয়? কিন্তু এর লেখো না সুরজিৎ দত্তটা লেখো তাহলে আমি কোনো জায়গায়
Especially, my lord, clauses 8.3 and 8.3c to be very specific.
রুল 9 দেখতে আর এইগুলো ওই বইটা আমাদের নেওয়া হয় এটা আর একটা সামনে আমি কলকাতাতে সব একই বই আমি বলবি দেখি কি করে পড়ছে
Yes, you are relying on which provision?
মাইলো
You are relying on which provision?
Provision as laid down, my lord, rule 8.3.
Yes.
Power to withhold or withdraw pension or gratuity in case of grave misconduct or negligence during the period of service, but which are non-related to the official job that has not been laid down under any section under that provision rules, my lord. That's so. There are many judgment. Even the Honorable Supreme Court that passed this order The departmental.
Which
proceedings
provision you are reading?
not related. In absence of any rule,
Please show us, sir.
Rule 4, my lord. No gratuity shall be paid to the government servant until the conclusion of the departmental or judicial proceedings and issue of final order therein. That
So-
is Rule 4C.
So where does it say that of the amount of loss which is to be recovered only to that extent? How we will read this into the rule?
That is, my lord, true. There is no specific, in absence of a specific provision.
First, it is true that you have made a
Au-
wrong
authority
submission regarding
cannot-
allegation. Now it is true that there is no such
No,
provision.
my lord, it is.
Then what remains?
No, gratuity is the fundamental right. my lord.
Yes.
He earned. That is not the.
Who is
property
saying
of
it
the-
is not? You will get it. If you emerge as a person the benefits can be granted, you will get it. They are not saying that you will never get it. Whether you are to get it right now or not, that is the issue. And having regard to the nature of allegations, two allegations by
But
two
until-
persons.
my lord, it is true.
One
but-
person of a different state, one person of a different state, or both of them you have said that I am giving you appointment.
He was in
And you
custody
say it
for
is
more
not
than 3
relating to
months.
service. Why do you make such a submission? You think you will get the order without us knowing this fact? It is there in record. We will find out. What is the point in saying something like this?
And in one matter, he was in custody for 3 months. In another matter, he
Yes,
was in
48
custody for
hours.
more than 5 months.
Oh, more than 5 months.
3rd January 23 to 29th May 23. So he was released on bail on 29th May 23, and he is superannuated just after 2 days on 31st May 23. Two separate cases. The tribunal comes to a finding that in one of the case, even charge sheet has been submitted,
Yes, we have seen that in one of the cases, charge sheet has been submitted.
and in the other case, the status is not available from the records. That's what the finding of the tribunal. Well, section the 8.3 subclause C is very specific, that no gratuity shall be paid to the government servant until the conclusion of the departmental or
8.3C or 8.4C?
Lord, it is 8.4C and 8.3.
Yes, 8.4C, not
8.3
3C.
and 8.4C.
Yes.
Until then, he is entitled to a provisional pension, which he is already
So
getting.
everything else he is getting
Yes,
only the gratuity has been withheld. Yes, take down. The issue arising for consideration
Publish.
Item number 5.
Item 5, my lord, I beg to appear on behalf of the petition. This is that matter, my lord, wherein
Okay. I was told Mr. Amol Sen, learned additional advocate general, is appearing in this matter, but I'm playing short passover.
He was here.
He
We
was
saw
here,
him.
but, he is on his legs, my lord.
See, we are only sitting till 12:30. 12 have a different, so tomorrow we'll
Kindly
take.
make it not today,
Tomorrow is-
Monday.
Oh, sorry,
Monday.
not today, yes.
Grateful, man.
Oh, there is a resolution. Much obliged.
item 6, lordship, I am appearing, lordship.
It has been shown.
Yes, lordship, yesterday, lordship, heard this matter regarding study leave.
Oh, yes.
Yes, lordship, I have the instruction, lordship, from my client, lordship. He is ready to forgo the salary. He want to pursue the course.
Who is for the state? In this case also, Mr. Sen is.
Amol Sen is present. Yes.
You have given them a copy.
Yes, lordship. He is present yesterday, lordship.
Just 3 minutes before he was there. At present, he must be there.
আপনি ইউনিভার্সিটির হয়েছে
Time behalf of the university.
Let us dispose of in light of the passed by Justice Kasa. What is the course?
Yes, lordship.
What is the name of the course?
PDCC, postdoctoral certificate course. Lordship, session 2024-25.
Postdoctoral certificate.
Yes, lordship. Postdoctoral certificate course, PDCC.
PDCC.
Yes, lordship. PDCC.
And it is any subject specific or it is
Yes, lordship. Lordship, neuroradiology.
sorry,
Neuroradiology.
neuroradiology.
Yes, lordship.
At which center?
Lordship, IPG-MER.
And this is since April
Yes, lordship. Started from April 25.
up to
Up to lordship for 1 year, lordship.
April 26.
Yes, lordship. 26.
1 year course. Just go through this. Quickly from here. This is the limit. Before the
এই তো এই তো
if he is getting the leave, study leave or without pay leave.
So he will file affidavit like that petitioner in the other case.
Yes, Lordship.
and giving the registration, admission, and
You are for?
West Bengal University of Health Sciences.
Oh, you are not for the state.
I am not.
I have talked with the principal of the college, but he was not posted with his petition. Yes, petition just yesterday. The telephonic call that I have had with him, they have serious objection because when he is released, well, the entire education, well, the imparting of the college will be hampered. Because there is no additional faculty in that college.
We thought he is appearing for the state. He said he has no objection.
For the university.
I would like to feel opportunity, I'd like to file a report manual because this requires your lordship's application.
No, what if he is not willing to, if he doesn't want any salary for the period, how can you stop him? Can you stop him from leave without pay? Do you have any jurisdiction?
So he has to take a permission back to apply to this course.
Yes, that is enough.
My
Ulusa vache.
instruction is the attendant.
Don't submit on telephonic instruction. You have a copy of the brief? So see what is there in the, before the tribunal. Then what clarification? You go by the records. All right.
And I'll satisfy you.
Don't just make submissions like that. Confine yourself to the records, not today.
I have already filed affidavit of service and kept on record. My affidavit service kept on record.
Yes, affidavit of service kept on record.
Item. For the state disbursement.
Item 7, Lordship. Yes, Lordship, I am appearing, Lordship. Very short point is involved in this matter, Lordship. Learned tribunal dispose of this matter, which is matter relates to departmental conclusion of departmental proceeding. Lordship, proceeding has already been started, Lordship. Charge sheet has been issued on 10th July 2024. I have every time
10/7/24.
24. And Lordship, I have always, Lordship, 14 occasions participated. I have cooperated with the authority. Lordship, tribunal dispose of this matter, Lordship, to conclude the proceeding within 6 months. But Lordship, I have in my pay application, I have paid in default. The proceeding should be vitiated. That is not, Lordship, recorded by the tribunal. Only for modification of that order, I am paying before your Lordship. And page 24 is my relief portion, Lordship, kindly.
Two judgments 2 days back.
No, my lord, in this matter, my lord, the charges are very serious. What I was on is, my lord, there are as many as 29 witnesses. And not only that, the charges are, my lord, of 50 pages. The documentation and all this. They have give reply of nearly 100 pages. So, my lord, can they believe that, is it believable, my lord, in 2 months or 3 months, this can be disposed of when there is 29 witnesses and allegation is misappropriation of fund and others, my lord. Is tune of 1 crore and there are landed properties also, my lord. He is the registrar.
Lordship, there is a criminal trial also.
no. That is
their charge, Lordship.
This charge is there,
That is
but criminal is there.
That is, you have made your submission. We'll come. Don't get impatient.
And in 13th of May 25, my lord, they give the reply. And my lord, most importantly, my lord, the tribunal application has been
So
filed on
from July 24 to May 25, they are not.
25. Their allegation is, my lord, that document has not been supplied, document has not supplied. But, my lord, at that point of time, if that be the so, my lord, then they have to come up before the court or the tribunal saying that the document has not been
So
supplied.
anyway, in May, they have finally filed their
Charge
reply,
sheet has been
written
filed,
statement.
and my lord, in 24/8/25, my lord, the tribunal, my lord, kindly takes tribunal's order second page, my lord. I'm not troubling his lordship the first page, my lord. The second page, my lord, what the tribunal held, my lord. Right. Oh, my lord, yes, my lord, kindly see, my lord. Kindly text from the first page, lord. In the decision of they are relied on a Supreme Court, but that is in a defined premise. I have checked up that judgment, but that is a defined premise. Delay of 9 years, 24 days in that matter, and that is led to a pension.
No, therefore, we are saying
Lordship.
last 2 days back, we have seen 2 judgments.
Correct.
One here is of Supreme Court authored by His Lordship Justice Maheshwari.
My lord.
One we have seen more recent of I think 25 itself, authored by His Lordship Justice Dipankar Datta.
Lordship.
On this issue,
My lord.
whether it is the tribunal has the jurisdiction to circumscribe with a specific limit that beyond this it cannot be done. So have you please see it. We don't remember right now, but those judgments are required to be considered because both judgments are on a
My lord, lordship may fix the timeline. We have no objection in that regard, my lord. Lordship may fix the timeline, but considering the, my lord, the gravity of the charge sheet, my lord.
No, but the timeline is already fixed.
Yes, that has been fixed, my lord. Now, my lord, they have come up for modification of that. That will not vitiate, but we cannot say, my lord. Suppose, my lord, 29
Yes,
witnesses.
we understand what you are saying. We have understood.
Lordship.
Having regard to the enormity of the exercise which is to be undertaken, you say it is not possible to fix a time frame.
Lordship.
But
Because of the voluminous document, my lord, and if it is charge sheet of, my lord, 10-20 pages, my lord, lordship may direct. But it's charge sheet of, my lord, 50 pages and 29 witnesses. That is the whole issue, my lord.
6 months from August.
From August, my lord. Not yet been completed. In February.
That it must be finished within this time, otherwise it will be.
Kindly, Lordship, for a moment, Lordship, look page 78. Lordship, I have received, Lordship, 18/7/24, the charge sheet. I have immediately replied that it is incomplete with the supplied the documents.
We are asking you
90.
an issue of law.
Yes, Lordship.
You say they have delayed in giving the documents.
Yes, Lordship.
All the delays attributable to them. Because of their delay, we could not file before May. In spite of filing in May, they did not complete. Tribunal says that since August, 6 months time is granted. If by February they don't do it, they should not be allowed any further.
Yes, Lordship, that is why.
So under which provision there is a right, or where the tribunal could have passed such an order? Where is the time limit specified in the conduct rules, service rules, anywhere?
Lordship, Lordship, the judgment of Lordship, I am relying paragraph 28.
Judgment.
Premnath Bali.
Of that judgment will be recorded in the tribunal's order.
Yes, Lordship.
So this is the only judgment you are.
Yes, Lordship. I will, like, at this stage, Lordship, I accept that provision, Lordship. Within 6 months, they can conclude. But if they not, what will be, Lordship, fate of my application?
So far that judgment is concerned, if Lordship comes to the last paragraph, paragraph 33, that their footings is otherwise. May I just read paragraph 33? 33 here, my lord, said 6 months. In paragraph 36, my lord, ultimately Supreme Court holds, my lord, in view of the foregoing discussion, the
31.
paragraph 33, my lord.
31,
Is
31.
33, my lord.
33.
The word, my lord, keeping these, my lord, what starts with keeping these factors in mind, we are of the considered opinion that every employer, whether state or private, must make a sincere endeavor to conclude the departmental inquiry proceedings once initiated against the delinquent employee within a reasonable time by giving a priority to proceedings as far as possible. It should be concluded within 6 months as an outer limit. Where it is not possible for the employer to conclude due to certain unavoidable causes, that has fallen from his lordship already, my lord.
We have seen, that's why
That's
we are saying.
Yes,
And it says it can be extended for 1 year also.
1 year also.
And
That
then,
tribunal he has hold on that issue.
and the court has considered that there it was pending for 9 years.
9 years, my lord.
So much beyond this 1 year also.
Yes.
Therefore, we asked him, where is any provision that there is any outer limit,
Statute, my lord,
that
he has
any endeavor should be made to conclude the proceeding within a particular time. There are such provision in many rules. Therefore, we are asking.
in tribunal, my lord,
Yeah.
nothing is on that short, my lord, is not there, my lord.
Lordship, it is ratio of judgment I have, Lordship, relied upon, and Lordship, in the meantime, I will forego, Lordship, the promotion benefit, everything. I will not get any independency of departmental proceeding.
What do you mean forego? You will not get anyway.
No, Lordship.
You will know whether you
I
forego or not, that is
will
immaterial.
not get anything, Lordship. The finance, that is,
Huh?
Lordship. I am sorry, Lordship. I will not get anything.
Your case will be considered kept in a sealed cover because charge memo has been issued. Only when the proceeding conclude.
Yes,
This is the general law.
yes,
Lordship, there is, they should, Lordship, conclude my innocence, they should conclude the proceeding within 6 months. If they did,
This third time you are saying this. Yes. We are not going to. Hello. Yes. As prayed by learned counsel for the
পরেরটা আছে।
eight.
Eight, my lord, I appear for the petitioner, my lord. My lord, I appear for the petitioner in this matter.
Yes.
Am I audible, my lord? And
You
I
are
also-
humble.
My lord, I appear for the petitioner. My
Yes.
lord, the case of the petitioner is this, my lord. The petitioner is a doctor. My lord, he tendered resignation from service. So, my lord, ultimately nothing happened. I approached the honorable tribunal. My lord, the tribunal seeking a direction upon the authorities to consider my representation with regard to my resignation of tender. My resignation is concerned.
Resignation simpliciter.
Simplicity, my lord.
What is the date of resignation?
My lord, resignation letter dated, my lord, 28th of January 2025. That is at page 62.
Yes.
So, my lord, the tribunal directed the authorities, my lord, to consider my case in accordance with law. Now, my lord, the authorities passed an order wherein, my lord, the authorities rejected my prayer for resignation in one hand, and the other hand, my lord, says I have to join within 7 days, failing which a proceeding should be initiated against me. My lord, that compelled me to file the second original application before the learned tribunal.
Yes.
Now, my lord, this being the situation, my lord, I moved the application on 9th of September. By that time, my lord, the honorable members of there is no honorable member of the tribunal. And my lord, by virtue of a notification dated 8th of September, the registrar in charge fixed the matter on 12th of January. Now, my lord, the predicament and the urgency is this. My lord, unless my resignation is accepted, I cannot pursue my own career in any way. My lord, I am already employed in one institution. I cannot be employed in others.
Where is the rejection of your prayer for
My
resignation?
lord, that is the impugned order. If your lordship takes up page 90. Not but
Yes.
now, my lord, your lordship kindly have a
Kindly-
look. Now, your
Yes.
lordship
Yes.
kindly have a look, my lord. The earlier original application which was filed, in that very original application, my lord, your lordship's order passed in WPSC.
Just wait. Please
As a
wait.
lordship. As a
Yes.
lordship.
Lordship, my lord, your lordship has seen the order rejecting the prayer for resigning from the post of assistant professor, Department of Orthopedics. Your lordship has seen. Now, my lord, the first one I'll submit, my lord, that I have seen, my lord, on day before yesterday, an advertisement in the newspaper Times of India that the administrative members, recruitment process of administrative members in the learned tribunal is on. That process is on. This is number one. Now, Lordship, kindly see the rejection order at page 90. Kindly see, my lord, the last paragraph I am placing. First of all, the conduct, my lord, then the last.
Page 84, 85 comes before 90.
Sorry, my lord.
Page 84, 85 comes before 90.
84, 85. No, my lord, 84, 85.
Yes, please read.
You're part of your lordship's order. Yes.
How many times we have to say the same thing? This is no reason that work will suffer. You can't stop him. This is no reason. That's why we are saying you want to argue the same thing again, which has been decided and which you have implemented.
Lordship, I bow down to Lordship's observation.
What is
Lordship,
this?
kindly have a look, my lord.
What look? You look at page 85 first.
Yes.
That judgment you have complied. And you want us to pass the same order again, that this is no ground, that patient will be
My lord,
suffering and work will be
paragraph
suffering. He-
17 of your lordship's order at page 85, I'm reading, my lord.
Yes.
Before concluding, we must take on record that fact that after having suffered many judgments as noted above,
Correct.
during pendence of the instant proceedings, also the Principal Secretary, Department of Health and Family Welfare.
Correct.
recently
We have
passed recent
taken
order.
notice of this fact that after suffering judgments earlier also,
Yes.
again you are doing the same thing. You want him to take an order from the tribunal or high court, then only you will. Can you
But,
do this as a state?
Lordship, one thing Lordship will kindly consider. My lord, this, there are 91 posts are vacant.
He doesn't care. He is not required to. That is your concern.
My lord,
He is
the
not required to. He is not asking you
hospitals have to
anything.
be- Hospitals have
His
to be-
resignation will be forfeiting his past service. His resignation will be forfeiting his past service, everything.
True, my lord, I'm not.
So how can you compel him to work?
My lord,
Where is
Lordship
the
kindly
provision?
sees that, my lord, here, my lord, the public interest
Who's
is.
concerned about that? He's not concerned. That's why we are saying you are arguing the same thing in every case. Public will suffer.
My lord,
Can you
Lordship
compel
kindly
him
sees,
to
my
work?
lord, the hospitals have to be run.
Sir, unnecessarily you are making a submission. Submission which has been rejected so many times, you want to make the same submission.
I've seen, my lord, some of them I have seen.
Then, if you have seen, then why don't you advise them that don't pass such orders?
Uh,
You are there to advise also.
my lord, these are, my lord, these are passed, my lord, at the administrative level. But my
So
lord,
you are not there to render any advice as a lawyer.
yes, my lord, I'll look into that, my lord.
What look into that? You are not looking into that. You are repeating the same thing which has been rejected at least 5 times we have seen.
Uh,
He is ready to forego his past service, everything. He wants to go home. Can you compel him to work? That is the only issue. Reason is immaterial. Do you have the power? If you have the power, then the issue will come whether the reason is sufficient or insufficient.
No, I bow down to Lordship's observation.
Then what can be done?
Now, my lord, Lordship kindly, my lord,
You
Well,
come back
should I-
with instructions.
should I? Yes,
Yes.
that's what I want.
Having gone through the
No, no, no. Well, I think similar matter is item 12, but let that be called on.
let it be called. You are appearing. In that case also you are appearing.
So I appear.
You are appearing.
Yes, item 12, Lord, sir.
In item 12 also, my lord, I appear. Same issue. my lord.
They are
In
also,
12 also will pass the same order.
they are also this order, same order may be passed in item 12.
Yes, that is in that case. Give us which page. The same writ petition order is annexed.
Well,
No,
the,
in that, Well, item 12, my lord, the authorities have accepted that I have a right to resign. They have accepted I can pursue my own case. They have accepted I'm not willing to have any pensionary benefit. Still, they have not given. My lord, this is a peculiar order. But they went on
So
to say
there-
90.
There also you have relied upon the same judgment.
Absolutely, my lord. I've relied on the lordship's
So
judgment.
therefore, same order can be passed.
So I'll come back, my lord, with proper instruction.
Yes.
affidavit of
I'll try to, my lord, but prevail upon them.
So
whether-
we are saying so because in one.
Lordship, I'll
affidavit, sir.
Lordship. Lordship, grateful.
এটা তো affidavit. হ্যাঁ
Big replacement.
হ্যাঁ সেম
Big replacement.
Item number 9.
yes nine lordship I am appearing lordship.
Lord, I beg to appear.
This is my affidavit of service. Lordship, appearing lordship matter relates to lordship compassionate appointment, and initially the authority lordship rejecting my pair only ground of married daughter. Thereafter lordship I moved married daughter. Thereafter lordship I have moved the matter and tribunal pass an order, and after quashing the lordship rejection order, tribunal direction given to the authority to take a decision within 3 months thereafter, but they have not complied. I have filed on contempt application, and in a contempt application lordship they have come with a lordship interim compliance report where it is seen that they have lordship sent the matter for vetting before the lordship labor department. Lordship, this is a judicial order. First of all, lordship, they cannot lordship send it. It is not the appellate authority. They have sent the matter before the lordship the labor department. Thereafter, they have filed the next date, filed the final compliance report where the same ground has been taken, that married daughter ground, when it is lordship already disposed of, so it cannot be reopened. So lordship, this married daughter, it is lordship, I am guided by the judgment of the larger bench of this lordship honorable court. And lordship, this matter lordship ultimately upheld by the honorable Supreme Court. And thereafter, the authority, lordship, the labor department issued a notification.
You have approached the tribunal for contempt of which order?
Lordship, contempt of the tribunal's original order.
Which order?
Lordship, order dated lordship 21/5 to the page number 38. Order dated 21/5/24. Wait. Last line, the impugned order dated 10/5/22 is quashed and set aside. Lordship. Thereafter, lordship, page 41, lordship, the contempt on 2/12/24, the tribunal fix the matter, Lordship, for order and allow for interim reason order. Lordship, page 40 is the Lordship final reason order.
Order, whichever order says to consider check. That was violated.
Lordship, direction to Lordship consider the matter on the light of the government notification. In
Which notification?
government notification, Lordship, it is mentioned, Lordship.
419.
Yes, Lordship, 419. Here, Lordship, after the judgment of the Lordship Honorable Court, the Labor Department has, Lordship, published the new notification on 4/11/22, where Lordship married, unmarried has been, Lordship, deleted.
That is 419.
Yes, Lordship, that is
That is 419.
Yes, Lordship, this is the notification, Lordship.
We don't want to see. We are asking you how it has been violated. That is
Lordship,
all.
because, Lordship,
We are not saying this is a correct order. We don't know.
yes, Lordship.
This may be a wrong order. This may be a right order. How it has not been complied?
Lordship, now, Lordship, kindly come when tribunal has already quashed the Lordship rejection order on the ground of married daughter. Now, Lordship, kindly come page 48. Page 48, they have, Lordship, rejected, again rejected that. Now they are.
Where they have said that because she is married, she cannot be considered.
No, Lordship, they have taken the point that after considering all the aspects of
They
the
have,
case,
please read the last paragraph. Hence, there is no scope. In the instant case, prayer has been made in respect of disposed of on 10/5/22. The 419 says matters which are not disposed of. Considering that they have rejected, there is no
Lordship, that is
contempt.
not the ground is.
That's why we are saying it may be wrong.
Yes,
We
Lordship.
don't know. But this is not the place to argue this. You can challenge this. Why
but
your
Lordship,
contempt is
the
still pending?
Tribunal, Lordship,
Your
yes,
con
Lordship, contempt is still pending.
you
Tribunal,
want to
Lordship,
pursue that, you can do it. Otherwise,
tribunal,
you may
Lordship,
challenge this order, whatever you want.
tribunal fix the matter before the division bench, as because there is no.
Forget it now. We see, unless we find any substance, we will not take it up.
But Lordship, my
Then we'll
submission
record that there
is
is.
when the tribunal has already passed the order and quashing the.
Now you are twice you are saying the same thing. You are again repeating that we have heard. What do you want? Therefore, we are asking you. You want to challenge this or you want us to dispose of the writ petition? As you like. If we are not here to advise you, but what is the purpose of the contempt now?
My submission was the authority did not follow the tribunal.
All right.
proper.
Third learned,
That is the
come.
submission.
Third learned advocate for the
appropriate forum.
What liberty?
Liberty to challenge this matter, liberty to challenge this order.
Your contempt is pending and you will challenge the order. Therefore, we asked you that what do you want to do?
Then Lordship. Obliged.
Deeply obliged.
না না
I think Justice Bhattacharya has some benches. After two,
We have a bench at 12:30.
oh,
Is in today's list.
oh my God, I have not seen the original set list.
Original site listed matter item number 1.
You have already encroached on their time 4
No,
minutes.
I should not, my lord. After that, Lordship will take up the appellate side. No. Monday then.
Well, the last occasion, Malad, I've made my submissions insofar as Malad, the facts of the matter are concerned, Malad.
Yes, you were to place some judgments.
Yes. The only thing is, Malad, I'll be distinguishing the judgments which has been placed by my learned adversary in the matter. Now, Malad, insofar as the Madras High Court judgment, Malad, reported at 2014 volume 1 CTC page 32, D. Prandhaman, that judgment, Malad.
Give us the compilation, please. Prandhaman.
Prandhaman, Malad. Prandhaman, as my learned friend says.
We stand corrected, yes.
Now, Malad, in this particular matter, Malad, there was no issue pertaining to the maintainability of the suit which was raised by the defendant. And Malad, the scope of the suit was suspension order, which was under challenge. The suit was filed on the basis of an alleged illegal suspension order, wherein, Malad, an application for injunction in terms of Order 39, Rules 1 and 2 were also filed. Now, Malad, over there, the trial court had dismissed the prayer for injunction, whereupon, Malad, the plaintiff petitioner had preferred an appeal directly, Malad, under Article 227. I'm sorry, Malad, it's not an appeal. It was a revisional application which was directly preferred in terms of Article 227 of the Constitution of India. Now, shorn of details, Malad, the scope of the suit in that particular case, Malad, was very different. It was directly, Malad, the suspension order which was under challenge. And the issue of the maintainability of the suit was never raised. Now, Malad, this was also not an issue as to whether the respondent club was a company or not.
At least, my lord, subject to correction, my lord, I have not been able to find any observation pertaining there. There were apparently the bylaws which were violated and the principles of natural justice not complied with. In the present case, my lord, it can be culled out from the pleadings itself that several opportunities have been granted and that those opportunities have been availed of by the appellant in while participating in the disciplinary proceeding. So, my lord, this particular judgment, the Prandhaman, as my learned friend says,
Yes,
my lord, that judgment, perhaps
we all must say.
we all must.
Milord, to just interrupt on a, so I was assisting Milord once Mr. Chidambaram in a matter, and there was a matter called T. Arivanandam on Order 7 Rule 11. Now the AIR version, AIR Supreme Court version has a misprint. So Honorable Justice Shonji Banerjee, as he then was, he had read the misprinted version and he said in T. Arivanandam. So Mr. Chidambaram got very territorial and he said, no, it is Arivanandam. Ariv means knowledge, Anandam means pleasure. It is Arivanandam. So, Milord, that is why sometimes councils get a little territorial about pronunciation. So, I learned that.
So, my lord, the scope of the suit in this particular D. Prandhaman judgment was completely different. So, the issues pertaining to the maintainability, apropos, my lord, Section 430 of the Companies Act, those principles were never applied in this particular judgment. Now, similarly, my lord, thereafter I'll refer to the judgment of Karan Singh Rewal, reported at 2020 SCC Online, Calcutta 1272. Over here also, my lord, the situation was there was a suit challenging the show cause notice, which was thereafter withdrawn, and a fresh suit was filed, which your lordship will find at paragraph 2 of the judgment. Just the sub paragraph, my lord, on the next page, if your lordship takes it up. On the self same date, the petitioner instituted title suit number such and such. This is the second suit, my lord, challenging the interim order of suspension dated 19 June 2019, praying for the following reliefs. Leave under order to Rule 2 of the Code of Civil Procedure. B. Decree for declaration that the suspension order dated June 19, 2019 is null and void, and direction that the same be delivered up and cancelled. C. Perpetual injunction restraining the defendant from taking any steps or further steps on the basis of or giving any effect or further effect to the suspension order dated June 19, 2019. Decree for perpetual injunction restraining the defendants from taking any other or further coercive steps against the plaintiff pursuant to the notice dated June 12, 2019 and suspension order dated June 19, 2019. So, my lord, even in this particular suit, there was no challenge whatsoever to the resolution which had been adopted by the general body.
In this case, we find that the court has made it further clear.
Made a few observations, but my lord, again.
No, made it further clear.
Yes.
You read paragraph 4.
Yes.
And then you read the last of paragraph 36.
Grateful. 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 Because that is the point, my lord, which I had also taken while making my submissions. Because section 241 and 242, read with 243 and 244, the ambit is very large. And as soon as, in fact, my lord, the plaint has to be taken as it is.
That is a settled law. There can be no argument on that, yes.
So, my lord, now, today, when the plaint, it can be discerned from the plaint itself that the claim in the suit emanates, my lord, from the challenge to the resolution adopted in the extraordinary general meeting. All the subsequent reliefs, my lord, are consequential in nature. And are not severable. They are inseparable from one another.
So here also you say only suspension was it.
Only suspension was the issue.
Anything else from this judgment?
Nothing else, my lord, because it gets, each of the judgments have to be taken in the facts of the case.
Then next.
Next, my lord, is the Vijay Chibar judgment,
Yes.
where again, my lord, the issue was, if your lordship kindly takes up the very first paragraph, have instituted the suit for one, declaration that the show cause notices, I'm sorry, my lord.
Yes, we are there.
Declaration that the show cause notices dated 6th October 2018 issued by the defendant to the 5 plaintiffs are unenforceable, illegal and void and not binding on the plaintiffs. And 2, permanent injunction restraining the defendant from taking any steps in furtherance of the show cause. So again, my lord, the scope of the suit was very different. Perhaps that is where, my lord, the Honorable High Court at Delhi as well as the High Court at Madras and, my lord, this Honorable Court had been inclined to entertain the suit as it is, because there was no challenge, my lord, per se, to the resolution adopted in a general body meeting, in a general meeting, my lord, which at the outset attracts, my lord, the jurisdiction of the National Company Law Tribunal in terms of Section 430 of the Companies Act. This was the third judgment, my lord, which had been relied upon by my learned friend, my lord. Now, my lord, my learned friend had also relied upon Vikram Jairat, which had also been relied upon by us before the learned single judge. Now, over here also, my lord, if your lordship is pleased to take up the internal page 3, my lord, of the judgment, which is, my lord, the continuation of paragraph 10. Paragraph 10, my lord, in fact, again, encapsulates, my lord, the reliefs which had been sought for. Over here, my lord, the claim was in relation to a challenge to a resolution adopted in a general meeting. If your lordship is pleased enough, my lord, to take up prayer B. Prayer A, my lord, is the declaration that the purported amendment of the Memorandum of Association of the Defendant Number 1 company providing for enhancement of its authorized capital, the purported enhancement of the authorized capital of the from 1.5 crores to 3 crores, the purported issuance of the bonus shares and the purported allotment of the same to the defendant numbers 2 to 5 is illegal and void ab initio. So that's a declaration, my lord, in respect of the Memorandum of Association. B is, my lord, the declaration that the board meetings dated 15th October 2018 and 1st December 2018 and the extraordinary general meeting dated 14th November 2018 of the defendant number 1 are illegal and have been wrongly and fraudulently held. Over here, my lord, the scope of the suit, my lord, related to, my lord, the challenge to the resolutions adopted in the extraordinary general meeting. And that is exactly the reason why, my lord, the Honorable Division Bench had eventually held that no, the scope of the suit is such which attracts the jurisdiction of the National Company Law Tribunal in terms of Section 430. That was the eventual finding, my lord. That is the reason why I say, my lord, this judgment comes to my aid rather than my learned friends. At the end of the day, my lord, one has to look, my lord, into the scope of the suit. What had been the scope of the suit in the judgments which had been relied upon by my learned friend, wherein the resolution, my lord, in the general meeting was not under challenge. So obviously, in the present case, my lord, It has been challenged, and the subsequent actions, which is the show cause notice, issuance of the show cause notice, and the suspension order, my lord, all emanates from that particular resolution only. And that is the reason why, my lord, those are inseparable from one another. And my lord, we have also relied upon several other judgments, my lord, insofar as the applicability of Section 430 of the Companies Act is concerned. That has been clearly dealt with by the learned single judge in the impugned judgment, my lord. What I've done, my lord, is I've prepared notes of argument. I'll append, my lord, these judgments along with the notes of argument so that it can assist your lordship. Judgment. Very, very. My learned friend has reduced my labor, my lord.
It's all there.
It's all there.
Yes.
So, my lord, I'll just file my written notes of argument, my lord.
That'll be all.
Nothing else, my lord. That I'll rest my case here.
May I take just
Yes.
5 minutes, my lord, to
Yes, please.
the only point I wish to raise, my lords, today is that
Just before Mr. Bishash begins, my lord, there's only one more thing. I had relied upon this judgment earlier also. I am not repeating myself insofar as, my lord, whether the appeal in its present form is maintainable or not. That is 2023 SCC Online Calcutta 2914. I had relied upon this judgment earlier also, and I've appended this to my written notes of argument.
You have given it in the.
I've given it, my lord. Grateful, my lord.
Mr. Sengupta had said that Mr. Sengupta had said that 241 and 242 might have might give the power to the NCLT to look at a case of suspension. Well, 241 and 242, I shall only point out, you know, the narrow scope of the NCLT and why I cannot, you know, today go to the NCLT, because 241, I'm not reading out the entire. If your lordships have.
Yes, you had argued that the residual power under Section 9 is much wider, and therefore.
Yes, my lord, I will not harp on that. My lord, that submission I've made, my lord, ad infinitum I have made that.
Yes.
My lord, there's only another point that I wish to touch upon. What, in essence, what I need to point out, my lord, is that Mr. Sengupta has shown 241 and 242, but the power to approach the NCLT is 244. That discretionary power, my lord, is so limited that the NCLT will not entertain my claims. My lord, may I kindly just place 241 your check to the. Let's just firstly kindly see 241 subsection 2. I don't need to actually place 241 2. You would kindly straight away, because 241 2 essentially say that the NCLT has to come to a conclusion that in other cases a winding up of the company would have been an appropriate remedy. 242 millets actually. I'm sorry, millets. 240.
We are wondering what you are reading.
No, millets, 242. I'm sorry, millets, because 241 is just oppression punishment. 242 powers of the tribunal, which is what Mr. Sengupta shown. 242 1B. Because both A and B millets have to be satisfied. 242 that the company's affairs are being run in a prejudicial manner, which is emanating from 241, and that to wind up the company would unfairly prejudice some members, such members, but otherwise the facts would justify the making of a winding up order. Because in this case, in no conscience at all can I approach the NCLT and say that the facts would otherwise justify winding up of the Calcutta Club just because an action has been taken qua me as a member and as the chairman of the finance subcommittee. Because the NCLT would have to be satisfied that if it is not unfairly prejudicial, then the company should be wound up because of this action. Just because the club has suspended me, I cannot today say that the club ought to be wound up, but it is unfair for the club to be wound up, therefore 242 will. No, Millard, I cannot say that. So this is not a case of oppression and mismanagement because I cannot make out a case of winding up. Now, Millard would kindly see 244, who has the right to apply. This is the discretionary remedy. (244)(1)(b) is the applicable provision, Millets, because this is a company limited by not by shares but by guarantee. 244(1)(b) and the proviso. Who has the right to apply, Millets? In the case of a company not having a share capital not less than 1/5 of the total number of the members. And the proviso gives the discretion, provided that the tribunal may, on application made to it in this behalf, waive all or any of the requirements under clause A or clause B of so and so too. So let's either 1/5 of the members of a company limited by guarantee have to apply, or I have to rely on the benevolence of the NCLT to think that suspension of a member from a club is an action which merits the club being wound up, but it will be unfairly prejudicial. So orders under 242 need to be passed. So Miller's discretion, and this has also been covered in the judgments that I've already placed before Lordship. Therefore, I'm not going into the judgments. That this honorable court in Vikram Jairath has also said that discretionary 244, 241, 242, these are very discretionary powers. So Miller's today, if I go before the NCLT and I am non-suited by the NCLT because the NCLT does not wish to exercise its discretion, then Millards would kindly consider the severe prejudice. That is point one. Point two, Millards, is what Mr. Sengupta has argued today, that the plaint emanates from the EOGM and the reliefs are inseverable. Now, Millards, when are the reliefs inseverable? When, if one relief goes, all the other reliefs will go. They will fall like a pack of cards. Now, let's today, if the EOGM goes, I had already argued that the suspension notice and the show cause notice can be seen on its own limbs. Even if the EOGM is held to be valid, the suspension notice can be seen and the show cause notice can be seen, and it can be held that the show cause notice was invalid, bad in law, suspension notice was invalid, bad in law. So, these are not inseverable reliefs. Had they been inseverable, then a similar situation like Vikram Jairath would have cropped up, where Mr. Sengupta has said that one has to look at the scope of the suit. That is where I join issue with Mr. Sengupta, elections. One has to look at the scope of the suit. And that brings me to that real cause of action phrase, Miller, that doctrine of real cause of action. Today, the scope of the suit in Vikram Jairath was EOGM. The scope of the suit in the judgments that I had placed was suspension. None of the judgments they had placed dealt with the scope of the suit where suspension or show cause notice from suspension from a club was an issue. And lastly, Millers, in Deep Randaman, the issue of maintainability was gone into, but there was a consensus across the bar and the bench that these judgments are maintained, these suits are maintainable. That is why, Millers, in para 9, the consensus is noted in Deep Randaman. 7 it is not in dispute that as per section 9 of the CPC, court has jurisdiction to try all suits of civil nature. Para 9.
That's what he said, that issue was not raised. He said it in a different way, that issue was not raised. He
And
said
let's-
regarding Vrindavan that
Yes,
the issue
but-
was not raised there regarding a maintainability.
It was raised in passing minutes, which is why para 9, the first sentence, as contended by Mr. Venkatachalapati, learned senior advocate for the petitioner, the relief sought for the suit relates to the civil right of the petitioner, which is not expressly or impliedly barred by any law. Which, Miller, here also my case is that no law under 430 bars the reliefs that I am seeking before the civil court, because 430 deals with matters that the NCLT is empowered to deal with under the Companies Act. Suspension and show cause notice are not matters that the NCLT is empowered to deal with under the Companies Act. Because 242 is very narrow in its scope, Millard. I need to make out a case that it would be fit to wind up the Calcutta Club, but it should not be wound up because it is prejudicial. I cannot make out that case, your lordships, that just because I have been suspended, it is fit to wind up the club. But these are my submissions.
So I wouldn't be rejoining Millard, but the only thing is one cannot perhaps Millard make submissions on the basis of surmises and conjectures that what might happen when that particular forum is approached. So perhaps again, we are in your lordship's hands, Millard. Grateful.
Hearing is concluded. The matter. That's right.